Regulations to curb the child labor and other things. To some extent, it may help the amelioration of the conditions of the child, but it cannot provide an equal opportunity for the child to grow. The Supreme Court and the several high courts have always they were keeping trust. They were keeping trust on the fact that the child education is a must. And now that the Constitution amended, the primary education is made a fundamental right. Primary is made a fundamental right, and then children will have the education. And free education is also given. Most of the government schools, everything, free education is given. In this context, I think an interesting case decided by Karnataka High Court recently, or by one of my brothers. We have you see, in every state you have got schools run by state syllabus pattern. And we have got schools run by ICSE and CBSE. They are the syllabus prepared by the central authority, and those schools run under the control of CBSE and ICSE. They are exploiting. They don't follow any of the regulations of the state with regard to reservation or providing to the admission to the schools for the underprivileged, and also fee concessions and all these things. They were virtually they were not bound by. So in one of the latest decisions, Karnataka High Court said that once you are running a school here, it may be that running a school. Education also should be a quality education. So that way the child rights get protected. And then we have got this. With regard to women, one of the interesting cases Karnataka High Court dealt with. See, after all, maternity, you have a preconceived notion that she should be married. Unless she is married, you can't have a maternity leave like that. The court held that no, it is not necessary that one should be necessarily be married to avoid the maternity leave. If she conceives, an unmarried lady conceives, she is also entitled to any other lady who is entitled to a maternity leave. This is also one of a decision of a far-reaching consequence. And then coming to it was not an issue in that particular matter, but I dealt with and laid down that such a practice is to be banished, and no insistence upon the accused, under trial prisoners or any accused to come with barefoot in the court hall. So this was done, and I feel that the Supreme Court and the High Courts, with all sense of pride, I would say that we are all committed to the spirit of the Constitution. We are working for the goals of the Constitution, and we must see the discriminations are also very peculiar. We have to go by the indigenous conditions. Our society is totally different from the other societies, and India is in the forefront. And even Indian courts have went far ahead in applying Article 21. Even to the non-citizens are also the rights are ensured. It's a very interesting situation where you find even a non-citizen is also entitled to a right to life. The right to life concept that is blossomed and expanded by the Supreme Court has really played wonders, and it has been giving proper direction to the authorities.
Thank you, Dr. Justice Rao. Colin, just to inform you, Justice Sedley, you said that he's not here, but
yes, sir. There's a short 20-minute but very interesting presentation.
Can we do it now, immediately?
We're ready, sir. It'll start in a minute.
Then we...
So we want to request Lord Anthony Lester to speak 2 minutes about Justice Sedley, and then we'll start.
Oh,
just for 2 minutes to introduce him.
Violence. That's more easily said than done, particularly in a country which has not shed its colonial legacy of police brutality. But it also leaps over what states are now finding critically important: the need to catch terrorism at the stage where it's being incited or planned. This too is a human rights issue. Once the bomb goes off, you may be able to catch the criminals, but you can't restore the lost lives and limbs of the victims. So the big issue, prevention, lies well upstream of the crime itself, located in social, religious and cultural strata in which the law ordinarily has no role. Yet it's here that intelligence has to be gathered, surveillance conducted, and sometimes interventions made. Can this be done without discrimination? And can it be done without constricting or violating human rights? The short answer to both questions is probably no. and I'll come in a moment to the consequences of this for the rule of law. But another question has to be answered first. If you can't combat terrorism without infringing equality and human rights, should you be doing it at all? Is it right, in other words, to sacrifice the very values on which your society is based in order to defend them? The answer at which both our countries have arrived is that it isn't an either-or choice. We don't have to tear up the rule book, but we may be justified in constricting certain rights in order to secure others. Article 30 of the Universal Declaration of Human Rights has always recognised the dilemma. It says, you remember, nothing in this declaration may be interpreted as implying for any state, group or person any right to engage in any activity or to perform any act aimed at the destruction of any of the rights and freedoms set forth herein. But what Article 30 does not do, and could not be expected to do, is to tell us where and how the balance is to be struck. It doesn't, for example, suggest that those who violate the human rights of others forfeit their own. Human rights are for the wicked as well as for the virtuous. All Article 30 does is forbid the use of human rights as a means of aggression. But this, as I hope to suggest, is itself a principle of some practical importance. Let me turn then to the complex question of how a society which is prey to terrorism but committed to the rule of law can legitimately intervene in that hinterland where most domestic terrorist activity begins, without forfeiting the principles of equality and non-discrimination. I'm excluding infiltration from abroad, which is ordinarily beyond the reach of domestic law and has to be handled in other ways. It's impossible to ignore the fact that most terrorism in our lifetime has been religiously motivated. That's not to say that its true sources do not lie deeper, for example in something as defensible as nationalism or as ignoble as tribalism. It's to say that the rhetoric in which much terrorism is promoted and sanctioned, the rhetoric of martyrdom, for example, is theological. Being theological, it enjoys the protection of two very basic human rights: the right to believe anything you choose, and the right to express what you believe in what you say and what you do. But the right of free expression is a right qualified and circumscribed by the rights of others and by the interests of society. We've recently had a striking example in England of where the border lies between the freedom to believe and the freedom to act. A relationship counsellor had been dismissed for refusing to counsel same-sex couples. His claim for discriminatory dismissal against the agency which had employed him failed at first instance and on a first appeal. Then, on his application for permission to appeal to the Court of Appeal, a statement made by a former Archbishop of Canterbury was not only put in evidence but released to the media. It accused the courts of being anti-Christian and demanded, I quote, a specialist panel of judges designated to hear cases engaging religious rights. As it happened, the judge before whom the application came was a member of the same church. In a memorable judgment, he said this: "In a free constitution such as ours, there is an important distinction to be drawn between the law's protection, highly contentious. Evidence about him, which the Home Office contended was too sensitive for him to be allowed to see, was submitted to the Parole Board. The House of Lords, in a split 3-2 decision, held that the Parole Board had inherent power to proceed by using a special advocate to deal with the undisclosed material." I need not conceal my own unease at this decision, since two of our most powerful human rights judges, Lord Bingham and Lord Steyne, strongly dissented on grounds of fundamental principle from the majority decision. They considered, as I do, that to allow the special advocate system to spread for reasons of convenience from a prescribed parliamentary regime, when even there it was no substitute for a fair hearing, to a quasi-judicial body to which Parliament had given no such powers, was to open the door to a serious dilution of principles of due process, which the common law, partly through the Judicial Committee of the Privy Council, had given to the English-speaking world, and which countries like India have adopted and developed in their constitutions and their case law. None of this is to deny or to trivialise the threat that terrorism presents to India's democracy and to ours. It is, I hope, to make two simple points. One is that it is not a weakness but a strength that a democracy does not abandon the principles of due process which it's struggling to defend, even if for a time it has to modify them. The other is that unless we are very careful, the exceptions we are compelled to make to our principles can become the rule, putting our societies imperceptibly into a permanent state of emergency and transferring command from the legislature and the courts to the executive. It's worth remembering that if terrorism can bring this about, it will already have achieved one of its major objectives. In the course of the argument before the Supreme Court in the freezing orders case, counsel for the appellants put forward an important argument on the implications of the historic compromise reached in the United Kingdom between Parliament and the courts in and since the 17th century. The common law, they argued, recognises the supreme law-making authority of Parliament on condition that Parliament will not surrender the law-making power and will only delegate it whether to the executive or to a supranational body, on terms which afford both control and place clear limits on the delegation. Our Supreme Court may come to regret its failure to accept the principled realism of this proposition and to adopt it as a corollary of the rule of law. Without it, democracy, I would suggest, risks being driven by terrorism into sacrificing both equality and human rights in the endeavour to save them. Thank you.
I guess Lord Lester can thank Justice Sedley on our behalf for his presentation. Now we almost reached the end of the session, but this is the session possibly with Justice Mishra was also looking for. That whatever we had discussed during these couple of hours after lunch.
Harmony with the social activists, I would say there is no failure. What you said, ma'am, with regard to the concept of victimology and the balancing factor of that, the human rights is always qua accused and not qua victim. There, though I am not totally disagreeing with you, but sometimes you see, you already reflected on the juvenile girls, if I remember correctly. You see, I have come across cases in Delhi. It is the accused sometimes really deserves more justice. I mean, there was a case, the girl of 12 years. She was booked under 363 and 366 of IPC. Is it imaginable? But it was so. What happened to that case eventually I am not going to say. That's a part of the system. Victim has a role, but simultaneously we really can't ignore the difficulty the accused is in. Which is the accused goes and again gets involved in something else. What you said today, at one point of time, I was thinking to myself, why the Parliament did increase the age to 18 years and on what parameters. Thereafter, in last 2 years, I participated in one seminar. I discussed with people who are real social activists without any kind of innovation. I discussed with my senior colleagues. I really convinced myself the enhancement of age to 18 years is justifiable. There has to be a reformation. One, while reforming these young girls or young boys, you see, I in fact faced almost an assault a danger to my life. You, ma'am, I sat on 3 occasions, though I had no reason to sit in a juvenile court. But I did sit. Apart from the infrastructure, the children who come. You see, I saw a small girl, 11 years. She has booked for an offence. How to deal with her? There may be another child. So what I only can suggest to you, actually some of our judges really have to devote some time to the juvenile home activities, adjudication process, as rehabilitation homes, de-addiction centers, and also study the background of the, we are not debating, but then just sharing and how to improve the situation. As my Justice Kabir said, this will take a day or 2, but which will be the monitoring committee, who will be the members. If you go to a social activist, they have a perception. There are child activists also. I presume you must have interacted with them. I do interact with them quite once in a month. There are 50 or 60 of them. The meeting goes on more than 3 of them thinking. I also know the victims are there. We have to really focus on them. But I am more concerned about accused in the juvenile courts. Such young boys looking this tiny. What is the offence? Theft. What are his stolen? Why did the police book him? Why did the magistrate shoot? Or we can't him bail?
Chief Justice, I think what we can do is we can leave this
Sir.
for another
Yes, that's what I want.
social discussion later on, maybe, because this requires consideration. Is there anybody else? There is a form which is an evaluation form, a feedback form, which is in front of you. I've been to request you to kindly fill this up so that some feedback is available from all the participants. You done it? Excellent.
We'll mail it back.
Please don't mail it back. No, they need it immediately. So, we've come to the end of for me it was a very fruitful discussion, and there are various things which have cropped up during this session which may require consideration, but then I think, as Lord Lester put it, after 2 days of sitting and listening and hearing, I think this is a very long time. Maybe some other time we can go into these various other things, questions. Colin, would you like to add something?
I just want to thank you, Justice Kabir, for chairing this session. And thank you all for coming here for the last 2 days. It's been an extraordinary, I think, experience. I've had an extraordinary experience. I think all the judges and the academics and all of you had a very fruitful 2 days. Thank you all for coming from so far away for this meeting. And I do hope, as you said, Justice, that we have many more colloquiums of this kind. Thank you all once again and have a safe journey back home. Thank you.
Could I just, on behalf of the foreign guests, what a great privilege it has been to attend this, and I agree that it's been a remarkable success, and I'm sure it's the beginning of the end. Thank you very much.